Good afternoon. My name is Anthony Russo. Today we're going to talk about insurers, policyholders, and defense lawyers, the ins and outs of the tripartite relationship. And I invite you to email to me your questions or comments during the presentations at the address you see on the screen, arusso@butler.legal, and I'll do my best to respond to you as we go along. Let's proceed. Let's talk about the tripartite relationship. We're talking about, of course, the relationship between liability insurance carriers, defense lawyers, and policyholders. And today, all of you claims professionals, all of you adjusters, all of you independent adjusters out there who work for the insurance company, we're going to be talking about your job and the origins of the obligations and the duties that you have undertaken to policyholders, your relationship with defense counsel and defense lawyers out there. We're going to be talking about your relationship with liability carriers and what is the basis of that relationship and what's the nature of it. And we're going to be talking about the relationship that you, of course, have with the policyholder, who, for you defense lawyers, is your client. We're going to be talking about each of these legs between the three entities in turn. And we're gonna break it down, so to speak, and then at the conclusion, we're going to talk about how those rules and regulations and statutes all interact. And sometimes our job is very clear and very easy, and other times it gets incredibly complex and difficult. We're going to be talking about some tricky questions that come up in the tripartite relationship that are of special interest. For instance, we'll be looking at a scenario, a real-life scenario, where the defense lawyer hired by the insurance company to represent a policyholder was deposed, or the plaintiff's lawyer sought to depose the defense lawyer, and the defense lawyer said, "No, I've got an attorney-client privilege with my client, the policyholder." And the policyholder said, "Well, I waived that privilege. I want you to testify." Can the policyholder waive the attorney-client privilege? We'll take a look at a case where the plaintiff, in the midst of a tort action, sought to obtain the work file, the claims file of that was held by the insurance company, looking for information about the claim. And the claims professional and his company said, "Well, isn't that work product? You can't have that now." But the policyholder said, "I waived that work product privilege." And the question is, can the policyholder waive the work product privilege that attaches to true work product that's held by the carrier, and under what circumstances? The final scenario that we'll look at the end of the presentation is whether the insurance company can be sued for the malpractice of the defense lawyer, where that malpractice results in an excess verdict against the policyholder, and the insurer steps in and pays that excess. And can that carrier thereafter sue the lawyer for malpractice when it pays that excess judgment? All real-life scenarios. We'll take a look at that at the end. Let's look at the relationship between the liability carrier and the policyholder. Well, it's a contractual relationship, right? There's a policy of insurance, and a policy of insurance is a contract, and the obligation of the liability carrier and the right of the policyholder under that contract is a defense and indemnity obligation. From these words that appear in most policies, either whether they're car policies or homeowners or boat policies, commercial general liability policies, from these few words springs a great body of law. We have the right and duty to defend any insured against a suit asking for such damages. The duty to defend, right? And the indemnity obligation comes from the words, "We will pay all sums an insured must pay his damages because of bodily injury or property damage." The words are in quotes here, were placed there in the particular policy I took this language from because they're defined terms. And of course, defined terms always seem to have room for disagreement, and when circumstances warrant, that give rise to coverage issues which will impact on the tripartite relationship and test the loyalty of the lawyer and the confidentiality of the communications. And we're going to get into that very soon. Now, this is not a history lesson, but as I understand it, that before there were policies that provided a duty to defend and a duty to indemnify, there were indemnity-only policies. So the policyholder would purchase this indemnity insurance if the policyholder were sued and if a judgment were entered against the policyholder. The policyholder would take the judgment and the policy to the carrier and say, I've been sued and here's the judgment and here's my policy, please indemnify me. Over time, apparently, carriers realized that a good product, a good business model would be to include a duty and right to defend the policyholder, because not only did the policyholder want this and they would pay for it, but also the advantages for the companies, they control have a hand in the litigation to assure that the judgment did not get out of hand, that defaults were avoided, that there was no collusion between the policyholder and the plaintiff, and improve their product. This is a very, very important policy term for an insured. This is a very valuable product, and people rely on it greatly. And you should understand, we should all understand as defense lawyers and as insurance professionals, just how valuable this is. If you've had a family member who's been in an accident, perhaps caused an accident, maybe hurt someone, you know that they may have been hurt themselves, that they may have hurt someone else, that they are liable to that person, and that they require defense. It can be a life-changing event in a serious emergency. You know, my mentor, Paul Butler, after whom our firm is named, I once heard speak to a gathering such as this, that our job we are in the service business. We are here to serve policyholders, among others, and to help them through a time that could be very, very difficult. And with that in mind, we approach our jobs. This language has been given, and I don't mean to demean it by calling it a judicial gloss, maybe a construction would be a better word for it. These simple words, we have the right and duty to defend, as now we find in our modern liability policies, by the courts. And there are many, many cases that you can find that define this duty and in different circumstances. I've picked out Boston Old Colony versus Gutierrez because it is cited and it's well known. It certainly is by no means the only case out there, but parts of this case have made its way into our jury instructions, for instance, and it's worth going over what the courts have said this duty to defend means for policyholders and to insurance companies. The Gutierrez Boston Old Colony case says, an insurer has a duty to use the same degree of care and diligence as a person of ordinary care and prudence should exercise in the management of their own business. This obligation, said the Supreme Court back in 1995, amounts to a fiduciary duty requiring the exercise of good faith. So in Florida, it's the policyholder first. That's the rule, right? The insurance company puts the policyholder ahead of its own interests. The insurer must assume a duty to exercise such control and make such decisions in good faith with due respect in regard for the interest of the insured. So you have to assume the duty. You have to be proactive. That's what this language is getting to. The court goes on to say you must investigate the facts, give fair consideration to settlement offers, and settle if possible, where a reasonably prudent person faced with the prospect of paying the total recovery would do so. And there, because the duty of good faith involves diligence in the care and in the investigation and evaluation of the claim, negligence is relevant to the question of good faith. And you'll see when you do your research, sometimes negligence alone is not enough. In other cases, it's just a factor. But this is the standard that is applied to the duty to defend a policyholder when they are sued for a covered claim. What does the policyholder owe in response to the liability carrier? What is the reciprocal obligation? Well, it's, aside from the duty to pay the premiums, it's a duty to cooperate, right? It's a duty to give prompt notice. It's a duty to provide papers that they're served with, to give statements, to cooperate, to give information, maybe to show up at trial. That's what the policyholder owes to the liability carrier. All right, let's move on now to the second leg of our tripartite relationship, the duty between the defense counsel and the policyholder, and vice versa. Well, it's an attorney-client relationship, right? The lawyer is hired by the insurance company to represent the policyholder. The rights and the obligations between the defense counsel and the policyholder are governed by the Florida Rules of Professional Conduct, which are promulgated by the Florida Bar in conjunction with the Florida Supreme Court, who is charged with these various responsibilities. These rules of professional conduct, and we'll get into them in just a moment, govern our obligations because we don't have a written contract. We defense lawyers do not have a written contract with the policyholder like the contract that is the policy of insurance. It's governed by these rules of professional conduct. When does this relationship start? Well, the rules of professional conduct state that the duties flowing from the lawyer-client relationship attach only after the client has requested the lawyer to render services and the lawyer has agreed to do so. That's a little bit different in the case of a policyholder representing a policyholder, and you'll find the cases out there if you look for them. The attorney-client relationship starts a bit earlier for us. The reasoning being that when the policyholder signs the contract for insurance and that contractual obligation is reached, the client, the policyholder, has turned over the duty to defend to the insurance company, and the insurance company, in the act of hiring the defense lawyer, has retained and created the relationship, and that's when it starts, when the attorney picks up the phone and it's the insurance company calling saying, I've got this case, please represent Mr. Smith. He's just gone through a red light and he's been sued. He hit another car, and it clears your conflict check, and you defense lawyers say, we accept the assignment, but that's likely to be the commencement of the attorney-client relationship, even though you may never have spoken to our fictional Mr. Smith here. What's the scope of that relationship? The scope of that relationship does not include Mr. Smith's will, perhaps that he's having written. It doesn't include a landlord-tenant dispute that he might be in, right? Those are simple examples. Of course they don't. The scope of your relationship is the defense of Mr. Smith and this personal injury, bodily injury claim that has been filed against him. And you need to limit, we attorneys need to define the scope of our representation with the policyholder, and we do that in an engagement letter, and that we're going to discuss at some length here as we go on. Now, the scope of that relationship is a much more subtle question when we get to the question of whether or not you, defense lawyer, also represent the insurance company in this action. Because under some circumstances you may, in others you may not. And it comes within what we're calling the scope of the representation. Let's talk about that we'll get into that in just a moment. Claims professionals, you need to know that the rules of professional conduct place upon defense lawyers several duties. A duty to consult with the client about the client's objectives. We know the client's objectives are settle the case, pay the claim, do it within policy limits, do it very quickly, don't bother me, don't take my deposition, just please get it settled. We know that's their objective, but the objectives might also be, don't settle with this person. That's a fraud. I don't want that claim paid. I want to resist this. There may be other aspects to the case, and each case is different, of course, that change the client's objectives, so they may not be perfectly aligned with that of the insurance company. And we know that the insurance company has the right, generally speaking, to control the litigation and to force a settlement even over the policyholder's wishes. All of it depends on circumstances, policy language, and the like. We have a duty to keep the client reasonably informed. That's why we write letters. That's why we pick up the phone and talk to the policyholder. We meet with the policyholder, and we talk to them about the case. We comply with their reasonable request for information, and we explain the matter in terms that that policyholder will understand, such that they are enabled to make an intelligent decision about the prospects that face them in this case. And that may include an excess judgment, which is a very difficult topic to breach with a policyholder, and one that is essential and should be made in terms such that the policyholder understands what they face, and such that they know if they need to seek other counsel, because it's beyond your capacity, defense lawyer, to give them advice. They need to understand this, and it should be documented not only for your own protection, but so that it's something that the policyholder can reflect on and maybe take to another lawyer not retained by the insurance company to understand their rights. Let's go to the final leg of this tripartite relationship. We're going to talk about the relationship between defense counsel and liability carrier. And here we have not only litigation guidelines and engagement contracts that are drafted by the insurance companies and signed by the defense counsel. We have a rule of professional conduct dedicated to this, and I've cited it in full because there was no way to shorten it. Let's go over it together, please. Representation of insureds. Upon undertaking the representation of an insured client at the expense of the insurer, a lawyer has a duty to ascertain whether the lawyer will be representing both the insurer and the insured as clients, or only the insured, and to inform both the insurer and insured regarding the scope of the representation. So you can be the attorney for both the policyholder and for the insurance company. And the circumstances under which you may do both or only one, and what you need to say differ, of course, with every case. Let me read a line from the Florida Supreme Court in a 1969 case. The interest involved in defense of liability suits is primarily and ultimately the interest of the insurance company. It is the insurance company's interest as an entity that the lawyer represents, whether house counsel or fee counsel. That particular line is pretty strong because we certainly represent the interest of the policyholder in several ways as well. A little bit more recently, in a case called Progressive versus SCOMA from the Florida 2nd District Court of Appeal, I think this decision was written by Judge Altenburn. He said, in many tort actions, then, the lawyer for the named defendant is also the lawyer for the defendant's insurance company, even though the insurance company is not a party to the lawsuit. So, lawyers, you go to a hearing and you're representing Mr. Smith in his vehicle accident case, and the judge looks at you, may see not only you as representing the policyholder, but also representing the insurance company who's not at the table that day or on the style of the case that the judge is handling. And you need to remember and be clear in your mind about who you are representing in the case, and be able to clarify that for the judge who's not privy to the scope of your representation. Let's talk about confidentiality and loyalty now, that we've sort of got the basics done about the tripartite relationship and the pieces of the puzzle that create it and hold it together. Two big factors are confidentiality and loyalty, right? By confidentiality, I'm talking about the communications between the lawyer and the policyholder and the lawyer and the insurance company. And that confidentiality is established by statute, and we're going to get into that in just a moment. And whether or not those communications can be shared or whether they're waived or can be waived is an important question for you to be mindful of when you're writing to the insurance company or when you're speaking to your policyholder. Loyalty, of course, I'm talking about a lawyer's essential duty of loyalty to a client, and you can't be loyal to a client if you don't know who your client is or who all your clients are. And if those clients are adverse, which one do you owe a duty to? And that's questions we're going to get into right now. Typically, let's take our Mr. Smith example. Mr. Smith drives through a red light and strikes another vehicle. Say he causes some property damage, no bodily injury. Say he's got lots of insurance and there's no doubt about the coverage. So he will be protected here, but he gets sued. The liability carrier calls you, defense lawyer, and says, can you take the case of Mr. Smith? Here's the facts. It passes your conflict check, and you say, yes, sir, we will take the case, or yes, ma'am. And you are representing Mr. Smith now. The confidentiality of your communications with Mr. Smith are assured by the attorney-client privilege. Is the liability carrier also your client? I would say yes in this particular example, because there's no divergence of interest between the policyholder and the liability carrier. There's no question of coverage, so there's no tension between the carrier and the policyholder. They both have a common interest, and that common interest is to get the claim resolved within limits. In that case, the confidentiality of your communications is assured, that your loyalty is not tested. Confidentiality is established by a statute, Florida Statute 90.502. Client's a person who consults a lawyer for the purpose of obtaining legal services. So, defense lawyer, when you speak to a policyholder and who's asked you for legal advice and you have provided that legal advice, there is a confidentiality that protects that communication. The question is, can you share that with the liability carrier without waiving it? Typically, shared confidential information is protected under the common interest doctrine, and that's also built into the statute, and you'll find it if you read that statute. I'm also citing a case here, Visual Scene versus Pilkington Brothers, although there's many cases. I'm citing Visual Scene because it's a good starting point for research if you ever have a question on the extent and the status of the common interest doctrine and the attorney-client privilege in general. But there's an exception, of course, and that's if you share this information with a third party, unless there's this common interest. An exception to the general waiver rule, it's called common interest or joint defense doctrine, you've probably heard it. It enables litigants who share unified interest to exchange privileged information to adequately prepare their cases without losing the protection afforded by the privilege. Okay, so long as you're in that happy place where Mr. Smith goes through this light, gets sued, but there's no question of coverage, there's no question of ability of the limits to pay for the damage. There's none of the tensions that arise between a policyholder and a liability carrier. Then in that happy place, this common interest doctrine is going to apply. You're going to be representing both parties, or party, Mr. Smith, and the non-party insurance company, and your communications can be confidential, even though shared, because you're preparing the case and you're entitled to the privilege. But when When the two clients become adversarial, the common interest does not apply. And a good place to look if you want an extensive recitation of how interest can become adverse, the Cohn versus Culverhouse case here gives an extended discussion of how communications and the confidentiality of those communications can either arise or be lost in the course of litigation. So if Mr. Smith and the insurance company become adversarial at some point, defense lawyers need to rethink their position. Can they still represent both the policyholder and the insurance company as clients? Must they change their position? Can they remain in the case? That's when your loyalty is tested. When the Rule 4-1.7 of our Rules of Professional Conduct says a lawyer must not represent a client if the representation of one of them is directly adverse to the other. And that's, of course, the easy circumstance would be a lawyer can't represent both the plaintiff and the defendant in a lawsuit. But it's much more than that. Let's say, in our example, Mr. Smith is represented by a defense lawyer, and the defense lawyer, in the course of communications with Mr. Smith takes you aside and says, hey, I wasn't really driving the car when we went through the red light. My 15-year-old son was driving the vehicle, and he's the one who got in the accident, and we just switched places. I didn't want to tell anyone because I didn't want to get in trouble. What now? Well, your happy case is no longer a happy one, right? Because your client, the policyholder, Mr. Smith, has just given you information that directly affects his coverage because there's no coverage for his son driving that car, okay? And you also have an obligation to another client, do you not, to give information that's relevant to the case and to the claim. So now you're in between a rock and a hard place. Which client do you have loyalty? Are they directly adverse? Well, if they're not already, they soon will be. And your place is not to be in the middle of them. And every case is different, and not are all so clear-cut as this one. But this is the way loyalty is tested for a lawyer who may, in the middle of a case, upon discovery of certain information, need to change the role and the scope of their representation. It comes about in other ways too, and we'll get a little more academic here and get away from Mr. Smith. Our conflict of interest rule states that a lawyer shall not accept compensation for representing a client from one other than the client unless the client gives informed consent. So the reason for this is the rules of professional conduct protect the lawyer's independent judgment and impose on the lawyer a duty to exercise that judgment independently. And if the lawyer is accepting money from a third party, the concern of the rules is that that third party will be calling the shots and interfering with the lawyer's independent judgment. Whereas if the client were paying the lawyer, the situation would be very different. A lawyer shall not accept compensation for representing a client from one other than the client unless the client gives informed consent. The concern here is that a third party, such as an insurance company, who's paying the lawyer may exert an undue influence on the lawyer's independent professional judgment to affect the representation of the client. And remember, the bar rules put the lawyer's loyalty to the policyholder, who is the client, paramount. But it's okay to do so so long as the client gives informed consent, which is where we're headed now. I'd like to turn now to a report of the Insurance Practices Specialist Committee that was commissioned by the bar several years ago now. It's the basis and the culmination of a lot of work and modern trends that guides a lot of the thinking and the work on the tripartite relationship. And if you're interested in the subject, I think your research is going to lead you back to this report and the work that was done. In the 1980s, And before and ever since then, there came a wave of insurance companies, from my recollection and during my practice term, of bringing in-house and the development of in-house counsel to defend bodily injury claims. These claims were typically handled or formerly handled by outside independent lawyers in their own law firms. And insurance companies consolidating some of this work in-house with their own lawyers who worked for them and who were their employees. There was also, during the 80s, a trend to impose litigation guidelines on defense counsel, telling them what they could bill, how much they could bill, what they could do, and creating very strict rules, some stricter than others, of course, about what the defense lawyer could do in the defense of the policyholder. There was also a trend, if you remember, the advent of the outsourced auditing companies. So the defense lawyer would prepare his bill, and instead of sending it to the insurance company, would send it to a third-party auditing company who would run through the bill to check for compliance with the litigation guidelines that had been established by the insurance company for the privilege of representing policyholders. This put a squeeze on the defense bar, and some carriers, more than others, were squeezing harder, and some lawyers, more than others, were feeling more squeezed, and it did create problems, and it bubbled up in complaints and comments to the Florida bar from the defense bar. And in 1989, the president of the Florida bar back then was Howard Coker, I believe, a great lawyer in Jacksonville, still practicing, I think, who commissioned the report of the Insurance Practices Special Subcommittee. And their mission, which is relevant to what we're talking about today, was to protect the public and those insured by policies of insurance issued in the state of Florida from the business practices of certain insurance companies. So this is by all means not all insurance companies. They had four particular concerns. The first one were the business practices of certain companies that constitute the unauthorized practice of law by non-lawyer employees of insurers. And here what they were concerned about, and this was sort of given voice, as I recall, at one of the public hearings that I attended, that the defense lawyer would get instructions from non-lawyer employees at companies, claims professionals, who would say, take this deposition, do not take that deposition. You can't do more than this many interrogatories. I won't pay for you, lawyer, to do this. That's a profession, that is a task for a paralegal. And such micromanaging by certain companies of certain tasks that it amounted to the unauthorized practice of law. And the Florida bar, of course, very concerned that only the trained, licensed lawyers practice law, otherwise there's no control over the profession. The second business practice they were concerned about was those that give rise to conflicts of interest or violations of the rules of professional conduct. And here, if you read it, if you dig into this report, which is not that long and good reading if you're interested in the subject, here they were concerned about those auditing companies. The bills of the defense lawyer contained work product or attorney-client communications or indications of those protected matters, and they were being given to a third party. And remember what we learned about confidentiality, that can be waived if it's shared with a third party. And these lawyers were concerned that the viewing of these bills, which contained these unredacted bills, constituted a waiver of that privilege and the work product, and they were concerned about it. The third business practice was generally stated to include those that compromise the quality of the defense provided to Florida insureds. In other words, some insurance companies were saying, you can take 2 depositions, you can have 1 CME, you can only take 25 interrogatories, and that's it, take it to trial. I use that as an example, but those were the type of complaints that were brought to the bar or to this special committee, and they were concerned that this kind of squeezing of the work of the defense bar in protection of the policyholder was resulting in a compromise of the quality of the defense. Finally, they were concerned about these business practices that failed to adequately inform Florida insureds of these limitations and the restrictions imposed on the defense counsel by the insurers. So, what came out of this year of hearings and work by the special committee, made up of members of the Florida Board of Bar Governors, insurance company, industry professionals, lawyers, plaintiffs bar, all came together and produced this document, and it resulted in the statement of the insured client's rights, among other things. This was enshrined in our Rules of Professional Conduct, Rule 4-1.8, and I'm sure all you defense lawyers out there are familiar with it. It is a Bill of Rights, so to speak, for the policyholder, letting them know many of the things we've just talked about, right? That you, defense lawyer, have been employed by the insurance company to represent them, that you're being paid by them, that you are giving them reports to which they are entitled, that they, the policyholder, are entitled to get a lawyer of their own at their own expense, and so forth. And this mandatory document, which was required to be given to policyholders, as stated in the rule, goes a long way towards remedying the problems that the defense bar was faced with. And this is the modern statement of the tripartite relationship as it exists currently. So we've gone over, now that we've established, the three legs of the tripartite relationship and what their sources are, where they come from, and how they operate together, roughly. And we've seen an example, or we've talked about an example, where there's no question about loyalty and confidentiality. We've talked, this is the case where the fictional Mr. Smith goes through the stop sign and causes some property damage. There's no question about his coverage. There's no question that there's enough funds to cover the liability. And lawyers, the confidentiality of your communications with the policyholder and the insurance company is assured. Your loyalty to both of your clients, and they are both your clients, is not tested. Let's go to, and that's 4 out of 5 cases, right? 9 out of 10 maybe. Let's go to an example, a real life example, where that wasn't the case, and see how these rules interact with each other. I've picked a case here. I call this "Whose File Is It Anyway?" I picked a case, and there's many such cases. I've picked this one because I'm familiar with it. It's Scottsdale Insurance Company versus, I'm just going to call it Latin Chamber of Commerce. So the Latin Chamber of Commerce in Miami gets a general liability policy from Scottsdale, and I think it was a slip and fall case. They get sued. There's a coverage question, though. So Scottsdale, appropriately, provides one lawyer to the Latin Chamber to defend in the tort suit. And then Scottsdale gets a different law firm and a different lawyer to commence a declaratory action suit separate to determine whether or not there's coverage and a duty to defend and indemnify. So what happened is the plaintiff in the tort suit is now a defendant in the declaratory judgment action, which is appropriate. And the plaintiff says, I would like to take the deposition of the defense lawyer over in the tort suit. And not only that, insurance company, I want your claims file, and I want to take the deposition of your corporate representative to talk about it. Well, Scottsdale in the declaratory action said, well, no, we object because, number one, our defense counsel has an attorney-client relationship with the policyholder Latin Chamber, and you can't get at that, at those communications. And number two, the work product that's contained in the claims file of the insurance company is protected by the work product privilege, and you can't talk to their corporate representative about those communications. The policyholder, Latin Chamber, said to the judge at the hearing on the motion for protective order, "Judge, I hereby waive my attorney-client privilege, and I hereby waive the work product privilege. Please let the plaintiff have the file, let them have the deposition, and let them ask the claims representative or the corporate representative of the insurance company about the denial or the reservation under rights of my defense." The trial court went along with that waiver and commanded the deposition and the production of the documents. Scottsdale filed a petition for writ of certiorari, which is the appropriate appellate vehicle to use in this instance, to test that order. Immediately, a petition for writ of certiorari takes the case immediately to the appellate court for review. It's a faster procedure if you're not familiar with it. And the Third District Court of Appeals, sitting in Miami, after reviewing the petition and the response, upheld Scottsdale's objection and quashed the order of the trial court that commanded the production of the documents and the deposition of the defense lawyer. The Third District said, "When the issue of insurance coverage is unresolved and at issue in pending court proceedings, a trial court must not order an insurer to produce its claims files and other work product documents." And that same reasoning authority applies to the testimony of the insurer's corporate representative. So you see what the court is saying here. Coverage was unresolved because it was at issue in the declaratory action. It was at issue, meaning there was a pending suit. And so in those circumstances where there's a pending suit that's going on concurrently with the tort action, that claims file, as appropriately defined, is protected by the work product privilege. As to, the court continued, neither the insured nor the injured third party is entitled to discovery of the claims file in a declaratory action to determine coverage because the claims file is the insurer's work product. It is your insurance company, it is your work file, it is your privilege to waive or not waive. It is not the privilege that belongs to the policyholder in these circumstances. Now, what constitutes a work product? That is the subject of an entirely different seminar, and we could go on and on about that, and you'll need to investigate each and determine what your claims file is in each case. The court, the Third District, said about the deposition of the defense lawyer, deposing opposing counsel in the midst of an ongoing proceeding is generally offensive to our adversarial system and is an extraordinary step which will rarely be justified, and they quashed the order. The liability, the defense lawyer in the liability case did not have to testify. Notice, though, that the court did not say anything about the question of the policyholder's waiver, because I think that the policyholder is the holder of that attorney-client privilege, and the question of his waiver, it was never addressed by the Third District, and I guess every case is going to turn on its own facts. Sometimes it's justified, and sometimes it's not. And again, that's probably the subject of an entire presentation of its own. But that's the way this particular scenario worked out. Let's go to the second scenario now. Bad faith global settlement. This is a situation as follows. Mr. Smith goes through the red light or the stop sign, and he hits two cars, causing so now there's multiple claimants. We have two people. And the insurer hires an attorney to attempt a global settlement of the multiple claimants. Let's say that the limits are $10,000 and the damages are easily exceed $100,000. So the insurer hires a lawyer to attempt a global settlement. I'm citing the Farinius versus Florida Farm Bureau case here, not because that's what I'm citing, that's not the source of my example, but because the Farinius case is a good place to start to learn about a liability insurer's duties to the policyholder in a multiple claimant situation. There are other cases as well, but the Farinius case is a good starting point for your investigation. Let's say in our example that the lawyer notifies the policyholder I've been hired to attempt a global settlement, but a coverage question exists and a declaratory suit is filed, just like in our Latin Chamber case. Let's say in our scenario here, the multiple claimant situation, there's a failure to reach a global settlement, and an excess judgment is entered against the policyholder, who thereafter Mr. Smith assigns his rights over to one of the claimants, and the claimant, one of the people injured in that accident, files a suit against the insurance company, a bad faith suit. Let's say in that bad faith suit, the claimant makes a demand for the deposition of the defense lawyer, makes a demand for the production of the claims file, makes a demand for, just as they did in Latin Chamber, the corporate representative. Well, the claimant's motion to compel discovery of the insurer's claims file should be denied, right? Because there's a declaratory action ongoing. Coverage is not decided. So the claims file and and what is truly work product should be protected. The claimant now, and look how we've gone from that happy place where things were so simple, where the loyalty was untested, the confidentiality was assured. Look, and just it's changing the circumstances slightly, how very complicated the circumstances have become, and how dangerous, in a way, for the policyholder, the circumstances have become, financially, and how difficult a question is presented for the defense lawyer and for the insurance company and for the policyholder and all around. The claimant cannot get to the claims file, but let's say the claimant, as an assignee of the policyholder, so Mr. Smith has assigned his rights in the policy over to one of the injured people. So now the injured person standing in the shoes of Mr. Smith says, I want the defense lawyer's work file. I want his file because I was the client, he was the lawyer, and his file was my file. And under many cases, the lawyer's file is the file of the client and must be turned over. Who does that lawyer represent? Well, that problem is solved whenever an insurance company in a multiple claimant situation hires two lawyers. Hires the first lawyer to represent the company and protect the company's interest, and hires a second lawyer to represent the policyholder. And in that way, instead of creating a murky situation where loyalty and confidentiality are not completely clear, to one where loyalty between the lawyer hired for the company, loyalty and confidentiality are assured, and for the policyholder just the same, and to avoid a problem like this down the line. Let's go to our third scenario, and I'll hurry because I know we're running short on time here. Can the defense lawyer be liable for malpractice to the insurer, to the insurance company? There are cases where an insurance company has sued defense counsel for malpractice after an excess verdict has been entered, and the insurer has paid that excess amount. Can that insurance company now sue the defense lawyer for that malpractice? In this particular case, which was never developed into never reached the appellate stage with a written opinion, the insurer claimed it was a third-party beneficiary of the attorney-client relationship between the policyholder and the defense lawyer. It had become subrogated, claimed the insurance company, to the policyholder for the malpractice claim, and that the policyholder had validly assigned his malpractice claim to the insurer. So there was apparently a written agreement between the policyholder and the insurance company when the insurance company paid the excess. Look how far we have come from that happy place where coverage was assured and where the limits were plentiful to pay for the liability. Now we're talking about the malpractice. It's just to cut to the chase, and this is not from the Marlin case that I'm reciting, but the Marlin case gives part of the answer to the question. In Marlin, the 4th District said the attorney retained to conduct the litigation acts in the capacity of an independent contractor responsible for the results of his or her conduct, and is not subject to the control and direction of the insurer. Thus, because the insurer exercises no control over the attorney's performance, it's not, absent an agreement, liable for the alleged acts of professional negligence committed by the attorney. So attorneys, that is both the blessing and the curse, is that it's your responsibility, and the insurer, who has exercised no control over your performance, is not responsible for your negligence. So let's sum this up. Let's talk about what have we talked about today. We've talked about the tripartite relationship and the sources of the obligations and responsibilities and duties between each of them. As between the liability carrier and the policyholder, we see that the source of duties that we need to look to are the contract of insurance, right, with the coverage provisions, court cases, which provide that construction and all that extra information and filling out what exactly your duties may be, and statutes like Section 624.155 and the Claims Administration Statute, which give further regulation about what an insurance company may and must do and what they can be liable for in defending liability claims. As for the attorney-client relationship between defense counsel and the policyholder, we know that the source of those obligations and rights and responsibilities are our rules of professional conduct and statutes as well, right? We've got that 90.502, which defines the scope of our confidentiality, of our communications with both of our clients or one of our clients, as the case may be. And finally, we know that between the liability carrier and defense counsel, we have a contract, right, which are usually the litigation guidelines or the engagement agreement signed by the law firm agreeing to undertake the representation of the policyholders. We have the rules of professional conduct, right, when the insurance company is the defense lawyer's second client. And of course, then would have the statute of confidentiality that also plays in there when we're talking about the common interest doctrine. So I want to thank you very much for attending today's webinar. I hope you found it helpful. Please feel free to email me at arusso@butler.legal, and I appreciate your attention.